Welcome everyone to this Privacy Espresso. My name is Alessandro Di Mattia. I'm Legal and Executive Officer at Privacy Rules. And today we are going to discuss with our expert from Germany, that is Volker Votianka. Volker is Attorney at Law and Data Protection Officer at Votianka Legal in Germany. And we are going to discuss about a very relevant case that happened recently, that is one related to the decision that one of the German DPAs, the Bavarian DPA, took in relation to the use of Mailchimp and exchange of data from the European Union to the United States. So, Volker, I think that we can immediately start having a little overview on what happened in this case. So I would like to ask you this, and of course, I thank you very much for being with us today.
No, thank you very much, Alessandro, and the community. For the nice introduction. The Mailchimp case is, in my opinion, a relevant example for how DPAs today follow up with the Schrems II case in Germany in this example, but we should also discuss what effects would be expected in Europe and European DPAs. The Mailchimp case is actually one that, and that's, I think, an important part, based on a specific case where somebody kind of accused Mailchimp or the controller that uses Mailchimp that it has been unlawful. It's not based on a DPA approach as such, but it's really about a complaint. Yeah, so that was the initial start of this case. Somebody complained, and then what did the DPA say? They deemed the transfer of personal data, in this case email addresses, so it's a newsletter service provider, unlawful. Yeah, I think that's important to understand. In the same way, or the reason why they deemed it unlawful was actually that the controller that uses Mailchimp did not have like a documentation to examine the risks on the use of Mailchimp. So accountability in this case was really the problem. There was no internal risk assessment on the use of an US service provider. And that was actually the problem. No fine has been imposed. And that's basically the important remarks on this case.
Okay, perfect. Thank you very much, Volker. And what do you think is going to happen in the near future? So in particular, under the German perspective, we know in Germany there are more than one DPA. Maybe the other one will follow or take a different approach. And what in Europe?
I think we really have to understand that this is based on a complaint, and I do not expect other German DPAs to follow up with Mailchimp or ask controllers to give statements on the use of Mailchimp as such. What is really happening is that, and that is the recommendation all DPAs give in Germany, and I think in Europe as well, that controllers are obliged to examine their data flows, especially to third countries, and when they have a third country data processing, to request supplementary measures from these providers in these third countries if they are not having an adequacy decision that is valid. As we know, Schrems II says PrivacyShield is invalid. And secondly, the issue is if you have EU standard contractual clauses and Mailchimp is working on standard contractual clauses, think about and request from the provider these supplementary measures. In this case, it was kind of interesting. The controller said, well, actually, there are discussions now on what is exactly the supplementary measures, the additional security measures like encryption, like erasure periods, like active defense against national authority, security authority requests, all these things. They said they are not final, these recommendations. And this is kind of an interesting argument. I would like recommend to use these kind of arguments as well. But Schrems II is almost 1 year ago, the decision, and there are many examples already where we see that kind of additional security measures give really a release to the risk and mitigate risk for controllers when they say we cannot really move from this third country provider to a national, to a European one. And so far, I think there is and actually also the move now from DPAs in Germany in a really coordinated approach on Microsoft 365, which is like a follow-up from the Schrems II case, a questionnaire that is primarily asking, do you use MS 365 and what are your measures? So that's the example in Germany where really DPAs go in a coordinated way. And as we know, the GDPR has articles that look for like consistency, like a consistency mechanism in Europe. I expect these kind of questions in other countries as well in the future.
Yes, perfect. Thank you very much, Volker. That's really interesting, and it's also related to, of course, the recommendations from the ADPB, and of course there is a lot of discussion there because many companies and lawyers are saying, if we strictly respect what the Schrems II was saying, we should shut everything down and not using. So
actually, I have these examples from AWS, from Microsoft. They provide, and I can only encourage controllers to require additional contractual papers. There are one-pagers, there are updated contracts from the big providers, and they refer to Schrems II and to additional safeguards. And this is the minimum you have to do, and I don't think then you must in any case leave these kind of providers. Yeah.
Okay. So speaking about this, because that's interesting. In your view, what a company should do, to protect his activity in order to be, compliant, because of course we know that many companies use Office 365, Mailchimp, and similar services. So what's your advice, and which are your takeaways also on the basis of what we have seen?
Actually, and that was the thing that the DPA in Bavaria deemed as unlawful, that the controller didn't do anything. So do something, document your action, manage third country data transfer, look into your data processing register, identify third country processors, send these providers messages or emails, requests. Please provide us with your Schrems II reaction in a contractual form. Give us additional security measures. Give us something that we can really deal with. And in any case, present the authority that we are in discussion with our providers. Also check and prove, of course, if you can transfer and move to a European provider as an alternative, because that was also published from one German DPA that they said if you present like evidence that you are kind of strictly bound into with one provider where you put everything, all your data in it, and you cannot move tomorrow. I mean, with a newsletter provider, I think you can move in between a week or 2 weeks to an alternative provider in another country. But when you, of course, think about MS 365 and other big platforms, it's more like a struggle. And of course, use that also as an argument. What is your plan? What is your management on that? And then I think the risk to receive a fine in this case also didn't end up with a fine. No, there was nothing. It was just a warning. And I think that's important, no? Because we usually don't talk about fines here.
Yes, perfect, Volker. Thank you very much for your very insightful comments and your support in this and your explanation. That was really clear and extremely helpful, I think. So thanks again for being with us. I would like to thank all our listeners for the recording, but also live here today for being with us. And I hope to see you all very, very soon again. So thank you, everyone, and see you soon. Bye-bye.
Thank you. Bye-bye.